Just to make sure you're all in the correct place, please know that this is a webinar to talk about Connecticut paid leave coverage for non-certified employees at public schools. Really great if the slides would move forward for me. There we go. So we're going to talk about Connecticut paid leave. We're going to talk specifically about the legislation, Public Act 25-174, which brings schools into our orbit. And then we're going to talk about your responsibilities under both Connecticut paid leave and Connecticut FMLA. When you receive the slide deck, you will receive slides that we will not cover today. That's the appendix that gives you more information that's useful for you to have, even though we won't have time to discuss it. This webinar specifically applies to public school operators, which is a term that was defined in Public Act 25-174. The definition of a public school operator includes local and regional boards of education, interdistrict magnet schools, charter schools, as well as an endowed or an incorporated academy approved by the State Board of Education to provide special education. So you might be a private school, but still considered to be a PSO or public school operator because you are providing special education pursuant to Connecticut statute. And then there's also a definition which includes cooperative arrangements between multiple boards of education as allowed by state law. Regional Education Service Centers, or RESCs, are comprised of local and regional boards of education, and they are also considered to be cooperative arrangements. So under either definition, RESCs do count as public school operators. Before we get into how the law changed, let's just provide a little bit of information about what Connecticut paid leave is. The Connecticut Paid Leave Act was originally signed into law in 2019 to create a source of income replacement benefits for eligible workers who need to take time away from their jobs for qualifying health or family reasons. Connecticut is one of 14 states, and including the District of Columbia, that provides state-operated paid leave programs. And we are one of 4 states where the program is entirely employee-funded. The employer does not pay any money out of the employer's budget. Rather, it is funded through a payroll deduction. So the employer is required to take 0.5% of their workers' paychecks up to the Social Security contribution limit and remit that to the Paid Leave Authority. We call these deductions contributions. The contributions are sent to the authority on a quarterly basis, where they are put into the Paid Leave Trust Fund. The Paid Leave Trust Fund is administered by the state treasurer, but it is not considered to be state money. It cannot be used for general budget purposes. By statute, it can be used only to administer the paid leave program and pay benefits. So if a worker needs to take time away from work for a qualifying reason, they apply to their employer for job protected leave under FMLA, but they can apply to the Paid Leave Authority for money for the income replacement benefits while they are away from work. The paid leave program stood up operations in 2019. The end of 2019 into 2020, we started collecting those contributions in 2021 and started paying benefits in 2022. To date, we have provided over $1.2 billion to more than 165,000 Connecticut workers. Our claims come from all across the state. I'm going to be using the terms FMLA and Connecticut paid leave a lot over the next hour. So it's important to define those terms. FMLA refers to the Family and Medical Leave Act. Slightly a misnomer because it's actually 2 separate laws, the federal FMLA and a Connecticut FMLA. Both have been around since the 90s. Federal FMLA has always covered schools, but you have to have a certain number of employees within a square foot radius. Connecticut FMLA has never covered schools, but will starting in October. The 2 FMLA laws provide workers with unpaid job protected time away from work. They do not require the employers to pay the employees when they're out on leave, although employers can adopt policies that allow for some income replacement, either by allowing employees to use their paid time off, or employer might choose to offer a short-term disability, but it's not required by law. FMLA is implemented by the employer and regulated by the Department of Labor. Connecticut paid leave was created to fill the gap for people who needed time away from work, where they were not getting money from their employer, and therefore were having trouble taking the time that they needed or coping with the situation. So our program creates a source of money for those eligible workers. It does not add additional job protected leave. It's really just about the money. And the program is implemented by my agency, the Connecticut Paid Leave Authority. We are a quasi-public state agency. We work with a third-party administrator. We have contracted with AFLAC. They do the processing of the claims under our authority, setting under our policies and direction. I also want to remind you that Connecticut paid leave and paid sick days are not the same, even though some people talk about paid sick days as being paid leave. Separate program. The paid sick days program is legislation that says employers should be required to provide some form of PTO to their employees. The paid sick days law has been on the books for a very long time, but used to apply to only a tiny segment of the population. In 2024, Public Act 24-8 amended the paid sick days law to cover eventually all workers. Really, it's just a question of the size of the employer. It's a graduated process. This law says that all workers, including boards of education and municipalities, need to provide their workers with at least 40 hours of paid time off to use if they are sick or a family member is sick or for a few other things. Many of you were already providing that PTO to your full-time workers. The difference was the law said that you had to allow those workers to use that accrued PTO in at least 1 hour increments. Apparently, that was problematic. Various entities lobbied the legislature and they amended that law this past session to say that boards of education and municipalities can require employees to use their PTO at increments set in their collective bargaining agreements. So if you have a bargaining agreement that says you have to use paid time off in 4 hour increments, that will apply. So again, that is different from paid leave because paid sick days are funded by the employer and they can be used really for any illness. It could be routine colds, it could be physicals, whatever. Whereas paid leave is employee funded and is used for more serious health conditions. We have information on our website at ctpaidleave.org, and the Connecticut DOL also has information about paid sick days if you're interested in that. But we are going to focus on Public Act 25-174 and how it brings Connecticut paid leave and FMLA to schools. There are 4 sections of Public Act 25-174 that are relevant to us. First, it defines public school operator, which we've already discussed. The big thing is that it mandates that employees of public school operators and non-public elementary and secondary schools who are not required to be certified by the Department of Education or the State Board of Education are required to be covered by Connecticut paid leave and Connecticut FMLA. So folks who are in positions that are not required to be certified will be covered under these laws effective October 1st. Does 2 other things that we'll get into in a moment, but I want to really focus on who's covered and who's not first. So as of October 1st, the definition of a covered employer under Connecticut paid leave will include public school operators with respect to employees whose positions do not require certification under Chapter 166. You all know who's required to be certified under Chapter 166 because there's a whole enforcement mechanism there. But just briefly, this means teachers and administrators continue to be out, whereas paraprofessionals, cafeteria workers, office staff, maintainers, right, bus drivers, they will now be in. For non-public schools, we're looking again at positions that do not require certification. Most non-public schools do not require anybody to be certified. So we will see teachers and administrators who work for non-public schools to be covered. Who's not covered? Well, employees of public school operators and non-public elementary and secondary schools whose positions require certification. There is an exception that has been on the books for a while now, which says if you are an employee who is otherwise not covered, if you're an employee of a school or a town and you're otherwise not covered, your collective bargaining agreement could negotiate for participation. That still applies. So your unionized teachers could theoretically negotiate in. I'm going to keep emphasizing the position is what we care about, not the person. So you could have paraprofessionals who previously worked as teachers, and they may still have their certification as a teacher, but they are not acting as a teacher for you. They're acting as a para. Their position does not require certification. That puts them in. Again, public employee, same definition, just with a different focus. Again, looking at that certification under Chapter 166. FMLA under Connecticut was also revised. Again, federal FMLA hasn't changed. You guys have been subject to FMLA on the federal side, but you have not been subject to Connecticut FMLA. Now you will, as of October 1st, as for your employees whose positions do not require certification. I mentioned there were two other things that the statute did. One of them was to give the paid leave authority the discretion to develop an alternative method for determining quarterly wages for covered school employees. The reason this came up is because the legislature was informed that some of these covered school employees, they're primarily thinking about paraprofessionals, might be given the option to select amongst various payment schedules. So they get paid the same amount. Say they get paid $40,000 a year. They could choose to be paid over 10 months, over 12 months, or over 10 months with a balloon payment in June. And it's up to the individual. It's not a school decision, it's the employee decision. Well, we determine our eligibility and our benefits based on quarterly wages. And for most workers, that's perfectly fine because you just get paid what you get paid. If you are in the same job as your friend across the hall and the friend down the hall, you get paid the same schedule, you get paid the same salary, you're making the same contribution payments. Of course, you're getting paid at the same calendar rate, but that's not true for all school employees. We want to make sure that there's no inequity based on that option for choice. So we're saying if there's a choice, we're just going to take the annual wages and divide that by 4. As a quasi-public agency, our rules have the power of regulations, and we have a public notice period, so we can make sure we get information from the experts before we adopt our rules. If you want to see this in its formal format, you can check it out on our website or check out Connecticut Law Journal. And we do eagerly await comments and recommendations, so please feel free to write to our general counsel, michael.caesar@ct.gov, letting us know what your thoughts are. We will then have our board vote to adopt the rule in September in advance of the October 1st start date. The other change relates to FMLA, again, trying to recognize the schools of slightly different operations than the rest of the general world. For Connecticut FMLA, in order to be eligible for leave, you have to be employed by your employer for at least the 3 months, translated into 13 weeks, immediately preceding the leave. There was some concern that that could result in some inequities for employees of schools, so they amended that to say for non-certified employees of schools or employees of schools whose positions do not require certification, they simply have to have been employed for at least 3 months during the previous 12-month period by that specific school. Just something to be aware of. Okay, so these are the things that changed, but for you, the entire program is new. So let's talk about your responsibilities under paid leave in Connecticut FMLA. On the paid leave side, we look at the contributions and we look at the claims. Contributions, the worker pays the money, right? It comes out of their paycheck, but the employer issues the paycheck. So the employer is the one responsible for taking that payroll deduction. In order to do that, you need to register with us at paid leave, you need to deduct, and you need to remit. If you have a payroll provider, the payroll provider needs to know that you are part of this. We work directly with payroll providers, so they should be aware. Maybe they told you to come to this webinar because we've been working with them, but you still have the ultimate responsibility. So first step, registering. You register on our website at ctpaidleave.org. We have information about how to register all there, but there are a couple of things you should know about. First, when we ask you for your business type, you will be picking most likely a public school operator in connection with your non-certified employees. But if you are a non-public elementary or secondary school, you would pick that. If you are a school where your teachers and other certified employees have opted to negotiate in, you would pick that option. That has not yet happened, except for one school. So we don't expect you to have that, but that's there in case you need it. One of the other things we ask for is, what is the date you first had Connecticut workers? The reason we ask for this is because that's how we determine the date from which contributions are required. New employers are created every day. Usually, the date that the contribution required is the date you first had Connecticut workers. But not for you guys. You've had employees for years. You are now newly covered. And so if you're newly covered, you would just add in October 1st. If you are entering through collective bargaining agreement, you would specify that date. Again, all sorts of information on our website, including a video on how to actually register. We have a new feature that we've rolled out this in the last 6 months that allows employers to request access to basic information about the employee's claim status in a report format. You're not going to see their med certs, you're not going to see any case-specific detail, but you can get a report showing the employee's name, case number, and if they're approved or denied, with the dates of claim and weekly benefit amount. The reason for that is employers like to have a report so they can reconcile their information. We need to make sure that you're a person who's authorized to have access to that information. It may not be your payroll provider or your payroll staff. It has to be somebody else. I apologize. I need to take one moment to pause. There's someone at the door. I apologize. Hold on one moment, please. So sorry about that. Let me go back to sharing my screen. If this is something you're interested in, this employer claim access, you can request approval from us. We do require some proof of authorization, and that information is also found on our website. So you register. You also have to remit those contributions. The contribution is due at the end of each quarter, but we give you a 1-month grace period. So, for example, quarter one, the deadline is March 31st, but we give you a grace period until April 30th. If the payments come in by April 30th, you will not incur any penalties or interest, but things that come in after April 30th will. Penalties and interest are the responsibility of the employer. If the employer fails to take the contributions from the employee's paycheck, the employer is going to have to pay that money itself. You cannot use contributions to pay interest or penalties. So it's important to be aware of this. Sorry. Sorry. Jess, can you verify that you can see my screen?
Yes, we can see your
Okay.
screen.
Just had a moment of doubt about that. Okay. So let's talk about claims. On the paid leave side, your employee is going to apply directly to Connecticut Paid Leave for their claim for benefits. They can apply online or by calling our administrator, Affleck. They will provide us with documentation. One of the things that they have to provide us with is an employment verification form completed by their employer, i.e. you. So what happens is the employee files a claim, we tell them what documents to provide, we give them the forms, they have to give you the form to complete. The statute says employees have to notify their employer that they have filed a claim with Connecticut Paid Leave. Usually employees do that by giving them the employment verification form. We are developing a school-specific employment verification form, which has information like, hey, does this employee work in a position that requires certification? And is this employee given the opportunity to select amongst various options how they get paid? So you'll give us that information. You can either give it back to the employee to submit, or you can email or fax it to us directly. We also ask employers to please engage in the good practice of letting your employees understand what paid time off policies you have, including whether you offer short-term disability. You should be doing that already. Just makes life easier if everybody understands. And of course, you are obligated to refrain from discrimination or retaliation against a worker who's filed a Connecticut paid leave claim. We will make the determination and issue the benefit approval. We will notify you if we approve or deny a claim. And again, you can get that information on a report level as well. If a claim is denied, DOL hears appeals of denials. But really, from a paid leave perspective, other than paying the contributions in and completing that employment verification form, employers don't have that much to do. Just want to mention, if you have employees whose positions require certification, who really are like, hey, we want paid leave, they can negotiate in. We have information on our website about that. If that happens, you do need to let us know. If one or more bargaining units collectively bargain to participate in the Connecticut paid leave program, then all of the non-represented employees who are not otherwise covered will also become participants. If you have multiple bargaining units and only one comes in, the others stay out. Big thing to know here is that no matter what you negotiate, you can't negotiate for retroactive participation in Connecticut paid leave. That it has to be prospective only. Also, employees can't negotiate for connection or protection under Connecticut FMLA. They can negotiate for a policy that mimics Connecticut FMLA, but DOL doesn't have an opt-in provision. Okay, let's talk about FMLA because that does actually involve you much more than us. When a worker needs time away from work and they need job protected leave, they need to tell you, the employer, and they need to give you, the employer, the documentation that supports that leave. So you, as the employer, are responsible for establishing the policy, posting the FMLA posters, which can be found on the DOL website. You process the leave requests, monitor the usage, and of course, refrain from discrimination or retaliation. Connecticut DOL has a lot of information on their website. Federal DOL has a lot of information on their website. I will say, we have our own forms that we give to workers, but we will accept if you say, hey, use the DOL medical certification form in connection with the FMLA form, they could give us a copy of that. I would encourage you to accept the copy of the CT paid leave med cert. It's got all the same information you're going to want. So to make life a little bit easier for the worker and the doctor, not to fill out the same forms twice, there's some value in being gracious there. So as a newly covered employer under Connecticut FMLA, again, you want to check out those FMLA posters on the CTDOL website. You do want to make sure your employees understand the rules. Eligibility for Connecticut FMLA is a whole lot more generous than it is under federal FMLA. So you're going to have a lot more workers become eligible. So you need to make sure they understand what their rights and responsibilities are. They still have to call in. They need to be communicating. That they need to provide you documentation. So you just want to make sure that everybody understands those rules. All right. I'm just going to take a couple of minutes before we get into the questions to just give you a few Connecticut paid leave and FMLA basics, just in case you're like, this is all new to me. The first thing to know about are the covered reasons for leave. These are the same under Connecticut FMLA and Connecticut paid leave. The one that you'll see most often is for someone's own serious health condition, the medical leave, right? Technically speaking, serious health conditions definition, which has like 7 subparts, includes serving as an organ or bone marrow donor, as well as pregnancy and childbirth. We treat those as separate leave reasons for tracking purposes, but it all involves having some form of inability to work and being under medical care. Most of our claims come from this. But you also get bonding leave. That's a second most popular reason for leave. That's leave that a parent would take to bond to create that physical and emotional connection with a newborn child or a newly placed adopted or foster child. Bonding leave is used by the parents. Again, birth, adoption, foster care, guardian, someone serving in local parentis. The person who's going to be raising this child can take bonding leave to connect with that child. Then there's caregiver leave. Caregiver leave is leave that an employee takes to provide physical or psychological care or comfort to a family member who has a serious health condition. In addition to these leave reasons, there's a few others you should be aware of. There's military caregiver leave, which is leave that is specific to individuals who've experienced a serious illness or injury in the line of duty in the armed forces. There are special forms that you use for this because you have to show that it was in the line of duty. And they get extra job protected leave if they're doing military caregiver leave. Qualifying exigency leave is leave that a worker would take if their parent, spouse, or child is either on active duty or has been notified of an impending call or order to active duty in the armed forces. The qualifying exigent circumstances are listed on our website and in the statute. They relate to things like attending a sending off ceremony or a welcome home ceremony or updating your legal documents, things like that. People can use qualifying exigency leave to obtain emergency child care. Say your spouse is the one who's the primary caregiver after school, and now they've been deployed, and so you need to find after school care for your child. The worker can use qualifying exigency leave on an emergency basis, but they can't say, all right, for the 6-month deployment, I'm out of here at noon. They can only use it for like the couple weeks that needs to get that new care in place. And then finally, there's something called the Family Violence Leave Act. This is not technically part of FMLA. It is a Connecticut state statute that's been on the books for over a decade. It's always applied to schools. It applies to any worker, any employer with 3 or more employees. It provides up to 12 days of job protected time off by a worker who is a victim of family violence. Last year was extended to include victims of sexual assault as well. They can use this time to obtain medical care or counseling, to obtain services from a victim services organization, to relocate, or to participate in a civil or criminal court proceeding. Again, this is separate from FMLA, but related, and people can get benefits from paid leave if they're out for these reasons. Again, I mentioned this already, but serious health condition requires both incapacity, which means inability to work or go to school, either because of the condition itself, because of the treatment for the condition, or because of the time necessary to recover from the treatment. It also requires treatment by a healthcare provider. So if it can't simply be take 2 aspirin and call me in the morning, right? You have to have something a little bit more significant. So it could be an overnight stay in a hospital, but it doesn't have to be. It could be you have a flare up for your chronic condition that you're under care for the healthcare provider and you're seeing that healthcare provider a few times a year for it. But when you have that flare up of a migraine, you don't go to the doctor that day. You just take the medicine that the doctor gave you. It also includes long-term care for which treatment is somewhat of a misnomer because you're no longer trying to cure the situation. You're really talking about palliative care. And of course, it includes pregnancy, as I've mentioned, and pregnancy includes prenatal appointments. You should also know that the definition of family member under Connecticut FMLA and Connecticut paid leave is broader than the definition under federal FMLA, and broader than the old Connecticut FMLA prior to 2022. Federal FMLA says you can only take caregiver leave to care for a parent, spouse, or child who is under 18 or is 18 and older who has a qualifying disability. But Connecticut FMLA and Connecticut paid leave says that you can take leave and receive benefits for a parent or spouse, a son or daughter of any age, you don't need to get into their disability status, as well as a sibling, grandparent, or grandchild, or an individual who is related by blood or affinity. Blood or affinity really relates to your chosen family. So it's a person with whom a worker has a significant personal bond that is equivalent to one of those family relationships I just mentioned. You can ask your employee for a written statement explaining the circumstances that says this person is equivalent to your grandmother or this person is equivalent to your sibling, but you cannot require an affidavit. You can't require it to be notarized. You can't require family albums. A simple statement is enough. The DOL has a form. We have a form. You know, basically we recognize that chosen family and we accept that the person who knows best who has a family relationship with them is them themselves, not the employer, not the state. Employers often get worried about this, but in practice, this is about 2% of our caregiver claims. And our caregiver claims are, you know, about 14% of our overall claims. So in practice, it's not really used that often, but for the family members who need it, it's super important. Okay, just a couple other definitions that you should be aware of. When you take leave, you could take it in a block period or a single continuous period of time. That's what most people think about. They think about, oh gosh, they're going to have knee surgery and they're going to be out for 8 weeks. But you could also take it on a reduced schedule. So maybe you need physical therapy, or maybe you need radiation treatment, right? So you're still working, but maybe you can't work on Tuesdays, or maybe you have to leave early every other day. And then there's intermittent leave. Intermittent leave is when you're absent for relatively small amounts of time, but you're out sporadically. We see this in two situations. One where someone's got like a chronic condition where they have flare-ups, and when they know that they're going to have a migraine, they need to go home, take their medicine, and lay down in a dark room. Or you see it often with caregiver leave, where it's like, hey, I need to take dad for his dialysis appointments. I'm not the only one taking dad to his appointments, but when it's my turn and, you know, mom can't do it, I'm going to need 2 hours off. Duration. You get up to 12 weeks in a 12-month period for most leave reasons. As I mentioned, military caregiver leave, you can get up to 26 weeks of job protected leave, but paid leave still only pays 12 weeks. 2 additional weeks of leave and benefits are available for individuals who are pregnant during their pregnancy, and they can use this for prenatal appointments or complications during the pregnancy, or if they happen to have the bad luck of getting sick from an unrelated reason during their pregnancy. And again, as I mentioned, family violence leave is capped at 12 days. I've given you a lot of information. I'm going to give you 5 things to remember and some information about where to go for more if you have more questions. First, again, paid leave is separate from FMLA. Claimants apply to their worker or to the employer for FMLA and apply to paid leave for the paid leave benefits. Workers need to get their documents to us by the due date. We do extensions of time readily. We actually give people an automatic extension, but the application is not complete until we receive all of those documents. And if we don't get all of the required documents, the claim will be denied. If workers are having trouble getting the documents, they can request an extension. If you are the employer and you are like, I'm having trouble completing this employment verification form, talk to your employee. Let them know what the trouble is. You know, we have limited information that we can share directly with the employer, but we're willing to help, and we can work with your employee to make sure that you know what you need to complete. We do ask employees to let us know if there are any changes. And if you, as the employer, know about a change, make sure that the employee knows to tell us. And finally, super important, particularly for schools, benefits are paid only for the dates that the worker would otherwise have been scheduled to work, but for the leave reason, right? So I know a lot of administrators work year round. So if you're scheduled to work in July and you need leave, you're going to be able to take your leave in July. But if you're only scheduled to work through June 20th and you're not coming back until August 20th, then we're not going to pay you benefits when you take your surgery in July. So it's just important for you to know that. It's also true for FMLA. If someone is not scheduled to work during a week, then they're not using their FMLA during that week either. So it's important for you to know as an administrator, but it's also important for your workers to know. All right. If after this session you have more questions, please check out our website at ctpaidleave.org. If you can't find an answer to your question there, you can submit an inquiry to our Contact Us. You can let us know if you want a phone call or an email back, and we will respond to you. If your workers have questions about already filed paid leave claims, they should really check it out on the paid leave portal, which they have access to, or they can call AFLAC directly. Again, we can't give very much information to employers. We can receive information, but we can't give a lot of information out because of medical privacy. But that's where the already filed claims questions should go. Questions about FMLA should go to either Connecticut DOL for Connecticut FMLA, Federal DOL for Federal FMLA, and their contact information is on the screen.